Hi, I'm Daryl Shorter, and I do want to thank you for using Doug Shorter Property Management. We are now going to go over the rental lease contract with you at this time. This is not the lease in its entirety, rather I'm going to hit the highlights with you now in this video presentation. You have a notepad in front of you if you will make some notes and ask any questions that you have once I am done with the video portion. And of course, if you want to take time to read over the lease agreement prior to my leasing agent signing it with you, that is perfectly fine as well. So we'll get right into it, and just so you know, I have a cheat sheet right here in front of me, so I'll be going over with you just as you have it there in front of you. This lease agreement has the location on item number 2 and the terms on item number 3. It shows the lease start date and the lease end date with you for us. Item 4 is the security deposit clause. That is telling us regarding the security deposit that we cannot use your security deposit at any time during your lease agreement. We can only touch that once you vacate the property, and per the Landlord-Tenant Act, we have up to 30 days to provide that disbursement to you. We are approving your occupancy based on the rental application that you provided to us, and the rent amount there is on a monthly basis, which is due on the 1st of each month, and you have a grace period through the 5th of each month. In fact, through 5 o'clock on the 5th before your rent is late. After that point, this is your notice there in bold that we could file an eviction action against you if your rent is late. So please don't be late during your occupancy, and if you ever realize that you will, certainly contact our office to make those arrangements, and if nothing else, at least to notify us that you are going to be late with your rent. Now, the rental late fees are 10%. Again, that's $501 on the 5th technically, and of course on the 6th if you attempt to pay it, you do have the late fee with the rent and the late fee of 10% of your full rent that is charged at that point. You can pay by personal check, you can pay online through the ePay system. If it comes back to us as NSF in either form, then there is a return check charge of $35 in addition to the late fee, in addition to the rent that is due. So just be aware of that and plan accordingly with your finances to ensure that the rent is going to be received on time and you have adequate funds in your account to certainly pay those charges as necessary. Section 9 talks about the occupants. Everyone listed on this section are the only ones that can live in this home. Nobody during your lease agreement can live in the property in addition to what we have here, unless, again, you make notification through our office. So please keep us aware if anybody is going to be coming to visit the property that will be staying longer than 10 consecutive days. We will renew the lease per the owner's instructions according to paragraph 10. So as we near the end of your lease agreement, if neither we send you a renewal or you don't send us a termination notice, then the lease will continue on a month-to-month basis. You cannot sublease the property, and that's in accordance with the section 10 that I talked about with you, and that is section 12. If anybody is staying there again 10 consecutive days or longer, that's basically considered subleasing. We do not permit that. Any utilities and services that are included are listed in section 13. Typically, no utilities and services are included, but on occasion they are, so they would be listed there as you can see. Now, section 14, which starts towards the bottom of page 2 and in the middle of page 3, talks about your obligations as the resident of our property. Talks about what you are and are not responsible for during your occupancy. When you flip over to page 3, you'll see pest control. If there's no infestation noted within the first 3 days of occupancy, pest control typically is your responsibility. Adverse weather, we do ask that in the event of storms or freezing weather, abnormally freezing weather, then we ask for you to take precautions with your property to prepare it in the event that these adverse conditions are going to occur. We typically will also send you out email information as well, so visit our website or give us a call if you have any questions. Mold and mildew is quite common in the low country of South Carolina. However, there are occasions where mold and mildew should not be occurring in ceilings, around pipes, things of that nature, very common along walls, etc. If you have those type of situations, certainly notify our office. But if you have it develop in the kitchen area or especially in the bathroom areas, that is quite common. Just clean it with some type of a cleanser, and that will take care of whatever issues that you may have with regards to the mold or mildew development. But if, again, there are problems, certainly notify our office in that event. Maintenance of the property, we will do what we can per the Landlord-Tenant Act to take care of normal problems within the property. heating and air, plumbing, electrical issues, all of those we will address as needed, so certainly report those to us. Inventory and appliances are listed on section 16. Those are what are included within the property. If anything is listed as a convenience item, that means we will not repair or replace them should they break down. So you want to note that towards the end of that particular section. We strongly recommend you get renter's insurance during your occupancy. It is a very small investment for your personal possessions. Whatever happens within the home, the homeowner is covered under homeowner's insurance. Our company is covered under liability insurance. Neither of these coverages protect your personal possessions. So that's why it's very important for you to get renter's insurance. Check with local insurance companies and they'll provide you with quotes for that. Very small investment for your possessions. I strongly recommend that you do get that. You can check out section 18 under indemnification, and we will turn it over now to right to access, section 19 on page 4. We can't just come into your home whenever we like. It would be nice, but it's not going to happen. You certainly have tenant rights. We can come in the event of an emergency and we need to secure whatever is causing the problem. We can come in between the hours of 9 a.m. and 5 p.m. for routine services. Actually, it's 9 a.m. to 6 p.m. for routine services, including routine inspections, which we will perform at least twice per year. We will notify you well in advance that we're coming. And between the hours of 8 a.m. and 8 p.m. for services that you possibly have requested. The only other time that we can come in without your notification is if we're performing an eviction and we need to secure the property or see that you're still there to ensure that either it's vacant or that you have vacated the property. If you're active military, we certainly honor that and thank you very much for your service to our country. If you do have to vacate under military transfer orders, you're still required to provide us with a written 30-day notice and a copy of your transfer orders, and we certainly will honor that on your behalf. Definition of a 30-day notice means 30 days prior to that event occurring, you have notified us in writing. Email, a hand-delivered letter, a mailed letter, letter in our Dropbox, or fax are acceptable forms of notification. But it has to be at least 30 days prior to whatever event that is. And that means if you mail it, it can't be in the mail 30 days prior. It has to be in our hands 30 days prior. So please check with us to make sure we have received whatever notification that you're trying to provide to us. If the property is damaged or destroyed and you have to vacate or you cannot use a portion of your property, then what we ask you to do is please immediately notify us in writing whatever the event has occurred, what your intentions are. The reason for that, we need to know what to do with your security deposit and we need to know what to do with your prorated rent. If you're going to be using a portion of the house or if you're going to be vacating for the time being but you plan to return to the home, then there are steps that we take for compensation for the rent. But if you're going to be vacating altogether, then we need to get that security deposit back to you as quickly as we can. If the property is condemned upon or foreclosed upon and you have to vacate the property at a certain point, unless it's due to structural failure, you still need to notify us as to what your intentions are. That does not preclude you from responsibility for the lease agreement itself. You're still responsible under the lease agreement, under our management, until such time that we're notified that there is a new owner in place. So all instructions will come from our office and not from a third party. Typically though, you will be the first to know about it. So in the event that that occurs, immediately notify our office that there's been some type of foreclosure action or condemnation with the property, and we will take steps on our end to see what is going on and to certainly protect your rights through the process as well. So just wanted to make you aware of that. As we turn over to page 5, if you're absent from the property, if you're not using it, that means typically that, well, we haven't received your rent, the utilities have been disconnected, we cannot locate you. We will go over to your home and gain access to the property to see if you're still there. If there are items in there of $500 or less in value, at that point we will go ahead and take possession of the home because we are looking for the owner's interest at this point. We may very well sell your items to compensate the owner for lost rents, so just be aware of that. Non-compliance with the lease or failure to pay rent, it's very simple. Just pay your rent, clear your account, and you're back in compliance with us. After 2 times, we're going to notify you that we may no longer accept rent on your behalf, that if it happens again, you may be forced to vacate. If we've gone into your home, for example, and done a routine inspection, and we find that you have a pet, that is unauthorized, then you're in non-compliance with the lease agreement. At that point, you have up to 14 days per the Landlord-Tenant Act to take care of that item, and once the pet is removed from the property, you're then in compliance. But please do everything you can to stay in compliance with the lease and to make sure that your rent is paid on time. But there are steps in the event that you are not in compliance. Once you vacate the home, we have up to 30 days to provide a security deposit disbursement to you. In the event that your security deposit does not cover all of the charges that are due, we can file against your credit through a collection agency to try to recoup those monies that are due to the owner. So be aware that even once you vacate the property, we can still not sue, but come after you for monies that are owed. If we do have to use an attorney, then we could charge for reasonable attorney fees. It's just, I keep reiterating, it's very important that you follow the lease agreement, pay your rent on time, and everything will be great. It's when you don't, when monies are owed, that it becomes troublesome for you as the resident, because this does affect your credit, and that's the last thing we want to do, but we will do so if need be. To reiterate the 30-day notice, a notice is defined as once it's received by us. That's when we have been notified in writing that whatever the notice is that you're trying to tell us has been received. You're waiving the right to put us on notice that we're in default of the lease agreement, because the Landlord-Tenant Act works both ways. You're waiving the right if you haven't notified us what the problem is. You have to physically tell us what your issue is before we can take corrective actions on your behalf. So just because a water heater goes out, that doesn't mean that you now have an issue with our company. You physically have to tell us what the problem is. We are granting you peaceful enjoyment of the property. Subordination, you can look at that clause on section 32, and I want you to also note on 33 that we are gaining interest off of your security deposit, but unfortunately you don't have access to that interest. You do have access to the security deposit, providing you follow everything within the lease agreement once you vacate the property. Rules and regulations are for your benefit and for ours to make sure there's a clear understanding. So if you'll glance over these, some highlights: no permanent changes to the property are permitted without our written authorization, and if you make any repairs, you cannot deduct those from the rent, again, without our written authorization. We don't own any of the properties that we manage. We manage them for private owners. We have to follow the wishes of those private owners. We have the set lease in place, but any changes you cannot make without our authorization per the owner. You cannot change the locks to the property. The subjective common elements, you can't put anything out in the common area if your property is subject to a common area without our notification or without the approval of the HOA. That's very important as well. If you have a motor vehicle, it cannot be broken down. Basically, it has to be roadworthy, has to have current registration, so you certainly don't want to have something without current tags as well. So make sure that your vehicle is not parked on the lawn. It's parked in the proper area in the garage or in the driveway. That is a lease violation if it's not roadworthy, or if you're parking on the lawn. You just can't do that. Unless you have an approved pet authorization, you cannot have a pet in your home for any period of time at all during your occupancy. I want to be very clear about this. Even if you're house sitting for a friend or for a relative, you cannot do that unless you have a separate pet authorization from our office. So be aware of that. Smoking is not permitted inside the property at any time during your occupancy. When you go to do the checkout inspection, you have to have your utilities on. We have to make sure that the power and the water are working during the checkout. If we go over to do the inspection and the utilities are shut off, then there will be a fee that you will incur because of that. So just be aware of that. You perform the move-in inspection. We perform the move-out inspection. We can be with you for the move-in inspection. We ask that you be with us during the move-out inspection. These are all for your benefit, to make sure that you've properly taken care of the home and that there are no charges against you that are frivolous, if you will. We're human. We can make mistakes too, but we try to be very thorough with all of our inspections prior to your occupancy, at your occupancy commencement, during your occupancy, and at your occupancy termination. We have to do this to be fair to you and to be fair to the homeowner. Our address for communication is section 36. We can accept fax and email as forms of notices. Those are perfectly fine. Megan's Law, especially if you have children or women that live at your property, check the sex offender registry to see where sex offenders are living. It is not our responsibility to provide you with where they are located. They move around just like you and I do. Megan's always out there for the benefit of you and I, basically. So just periodically check to see who's around your community to see where those sex offenders live. That's for your benefit. This entire contract that we are signing today is binding and ensures the benefit of you as the tenant and us as the landlord. If there has been anything said to you by any member of my staff with regards to this lease agreement that contradicts what you're signing today, please bring that to the attention of the leasing agent's information. We will certainly address that before you sign anything. The property management clause is for our benefit, and it improves communication with you and with us. You at no time can communicate directly with the homeowner regarding the lease term, lease amount, anything regarding your lease agreement. That is with our office. The homeowner has signed a management agreement with just the same language in there that they cannot speak with you with regards to your lease agreement. This has nothing to do with repair issues. If a homeowner approaches you at your property through our office, that's perfectly fine to discuss repair matters. But when it comes to the lease agreement, to save any headaches, to save any miscommunication, all communication with regards to your lease comes through our office. The owner is aware of that as well. So you and the homeowner are violating the lease agreement if you circumvent our office and discuss leasing matters directly. I want you to be aware of that. It's been a problem in the past, so with that in the lease agreement itself at this point, it should no longer be of issue. If there are any additional terms, pay close attention to Section 43. They're written in there, and that applies specifically to your property. The final page is where you're going to sign. However, I want you to note that there are some addendums that will be in there, and the leasing agent will bring the addendums in, and we'll go over those with you that you will be asked to sign in addition to the lease agreement. As I mentioned, at this time, you can take as much time as you want to read thoroughly the lease agreement with us before you actually sign. I've gone over the highlights with you. I don't want to spend a lot of your time today. I know you're anxious to get moving and literally get over there and get settled into your new place. Hopefully this video today will help you understand a little bit more what these sections within the lease agreement itself are, basically for your benefit. So I'm done. At this point, take as much time as you want. If not, go ahead and speak to the leasing agent and let her know that you're ready to go ahead and sign the paperwork.